Good evening. Welcome to the Community Awareness Committee's December panel discussion. Our topic this evening is government. I am Trish Steiner, Chair of the Community Awareness Committee. For those of you who are joining us for the first time, the Community Awareness Committee is a committee of the Neighborhood Safety Commission. The Neighborhood Safety Commission is comprised of 50 individuals who are appointed by the chairman and the district commissioners. We welcome you and thank you for attending this evening, and welcome those of you who are watching on Cobb TV. Our committee members are Pearl Roberts and Joel Cope. Please turn your cell phones off or on silent, as your phone will interfere with the broadcasting of this discussion. Thank you. Our moderator this evening is Joel Cope. Joel is an attorney whose practice is in trial litigation, and he has been a practicing attorney for 18 years. He currently serves on the Neighborhood Safety Commission and serves as its chair for one term. He served as the president of the Mableton Improvement Coalition and president of the Mableton Community Fund. He has also served as secretary and president of his HOA and was appointed by past county commissioner chairman to serve as a member of the Transit Authority Board, eventually obtaining the position of this board's vice chair. Thank you so much, Joel, for being a phenomenal moderator this evening. We appreciate that, and we appreciate you doing that. And I will turn it over to you, and you can introduce our distinguished panel members.
Wonderful. Well, thank you, Trish. I appreciate that. Again, my name is Joel Cope, and I'd like to thank the members of our audience that we have here tonight, as well as those folks who are watching us on either TV 23 or who are watching by way of the internet. Just by way of reminder, this broadcast will eventually be uploaded onto the website for the Neighborhood Safety Commission, which is part of the larger county's website, so you can also view it as well. We want to thank our distinguished panelists tonight who are kind enough to share their time and intellect with us to shed some light on this very important topic. I want to introduce each one of these individuals to you briefly, but I also want them to have the opportunity to introduce themselves more fully and give you the breadth of their experience, because I think each one of them has a lot of experience they bring to the table and the expertise that they'll be sharing with us this evening. And I'll introduce them in no particular order. Tom Charon is currently serving as the court administrator for Cobb Superior Court, but obviously, as many people know, he served for a long time as the district attorney for Cobb County.
Thank you, Joe.
And we also have Vic Reynolds, who is our current district attorney for Cobb County. Fortunate to have him with us as well tonight.
Thank you, Joel. Good to be with you.
And I also have Brucey Patel, who is an attorney himself, and he's also active with the Georgia Municipal Association. And he's kind enough to come and share his expertise with us as well tonight.
Thank you for having me.
Certainly. What I'd like to do is first go to Mr. Sharon, if you'd be so kind as to share with the audience a little bit more about your background, and then we'll go to Mr. Reynolds and then Mr. Patel, and then we can kind of lead into the program materials that we are going to cover tonight. We do have the ability for folks to ask us questions that we can ask them to you, in addition to what we have here that's been submitted previously to tonight. But again, I want the audience to have the chance to learn about your experience and how we came to be fortunate to have each one of you here tonight with us.
Well, thank you, Joel, and it's a real honor to be here this evening for this particular panel discussion, something that's I've kind of lived for most of my professional career through the court systems. I started here in Cobb County as a practicing attorney back in 1973. I just look a little older than I actually am. After practicing law in general practice for 4 years, I ran for district attorney. In 1976, was elected district attorney that year and served until 1998, 6 terms as district attorney. Of course, the district attorney, as Vic will tell you, is the chief law enforcement officer for the courts in the jurisdiction of which they serve. It is an elected office. The district attorney runs every 4 years. It is a partisan office, so the district attorney runs as either a Republican or a Democrat. I ran as a Republican and was a Republican district attorney for the 21 and a half years that I was district attorney. In 1998, I had the opportunity to go with the National District Attorneys Association, which was the national organization that represented all state and local prosecutors throughout the United States. My first role with them was to start the National Advocacy Center on the campus of the University of South Carolina in Columbia, South Carolina. It was a training center for both federal prosecutors and state and local prosecutors. We trained young prosecutors how to try cases, as well as how to handle the press and also office administration. I was there for 6 years and then was appointed the executive director of the National DAs Association in 2004, and went to Washington, D.C., where our national headquarters were, and served in that capacity for 4 years before retiring and coming back to Cobb County. I intended to practice law, Joe, like yourself, but made a visit to the courthouse and saw several of my old colleagues who are now judges of the Superior Court. They asked if I would be willing to take a short sabbatical and be the court administrator for 3 months, and that was 7 years ago, and I'm still there. So it's a delight to be here tonight and to talk about these issues.
Well, thank you so much. Mr. Reynolds.
Thank you, Joel, and good evening. It's an honor and a pleasure for me to be with you. And let me commend the Neighborhood Safety Commission for the work they do. It's a tremendous honor to be part of this panel and several others in the past, and so it's a pleasure to be with you. I have a pretty varied background myself. I had the honor of being a police officer. I was a beat cop right out of college and worked as a police officer for several years. I ultimately made the investigator position and worked in law enforcement for about 4 or 5 years before being accepted into the second class at Georgia State Law School in Atlanta. I left the law enforcement field and went to law school, and upon graduation I had the distinct honor of going to work for Lewis Slayton, who was the district attorney for a number of years in the Atlanta Judicial Circuit in Fulton County. I prosecuted for Mr. Slayton for several years before Tom was gracious enough to offer me a position, and I had the pleasure and distinct honor of coming up and working for Tom Sharon as one of his prosecutors. After a period of time of working in that office, I was in the right place at the right time, and again was very honored to be appointed as the Chief Magistrate of Cobb County, where I presided over the Cobb Drug Court, which was a specialized court handling cases made by Undercover Narcotics Squad in Cobb. I sat in that position for about 6 years, running successfully for election back in 1996. And after serving a term there, I left and went into private practice, where I was a practicing attorney in Marietta, in practice with a lawyer named Jim Berry, a fine lawyer. And Jim and I practiced together for about 13 years and really felt the yearning to get back into public service. And the opportunity opened up for the DA's position, a job that I'd always held in great esteem, and was very humbled to have the opportunity to run for that position in 2012 and was elected that year. Took the office January 1 of 13 and have been DA since then. So that's a little bit about my past. And again, I'm very honored to be with the Neighborhood Safety Commission this evening.
Thank you as well. Mr. Patel.
Thank you for having me, Joel, and thank you, fellow panelists, for being here and learning about you, and members of the audience. Rushi Patel with the Georgia Municipal Association, and I think a good background of the Municipal Association, because not many people know what that is. It's an association that is comprised of about 520 cities in the state of Georgia, and there's only about 540 cities in the state. So most cities in the state of Georgia are with the Municipal Association. I began my career as an assistant city attorney with the city of Brunswick, which is down on the Georgia coast near St. Simons. And a little after a year after I'd been down there, I was offered the opportunity to also be the city solicitor, which I gladly took up. The recession creates great opportunities sometimes. And it was a new experience for me, and I was able to prosecute misdemeanors in the municipal court. And I did that for a few years, and in 2010 I came to the Georgia Municipal Association, which is a great opportunity. And the Municipal Association represents these 500 some odd cities in multiple ways, at the state legislature, lobbying and providing advice to city attorneys, municipal judges, and various other city officials throughout the state. I was fortunate enough to also get involved with the International Municipal Lawyers Association, and somewhat to my surprise, in 2012 was given an award for being the Young Public Attorney Award for the Municipal Lawyers Association, which was great. And I will be entering my 6th legislative session coming up in January, and it's always an adventure, and I'm glad to be here. Thank you.
Wonderful. Thank you, Ms. Patel. Appreciate that. Again, just for the benefit of our audience, this particular topic came about because we had an interest expressed by persons who did not know much about the government structure and how the government interacts with different levels of government, city, county, state, and also how this interplays with the public safety arena, which is, of course, what we're tasked with here and what obviously many of you spend your time working on every day. So what we're going to do to start out with is sort of kind of a basic civics 101 type approach, and then we're going to kind of bring it into the relevancy with public safety. For those folks who never heard this will be very educational. For those folks who hopefully covered this in high school, this will be a refresher course since maybe you don't cover that in your day-to-day work. But I want to pose these questions to our panelists, and all these questions are designed to be able to be answered by each one of you. We didn't purposely draft these questions to where any one person can answer them. For the sake of our viewing and listening audience, what does the concept of federalism mean?
Yeah, I'll touch on that, Joel.
Sure.
And I'm sure these gentlemen can add to that. The concept basically is a situation that, recalling on my civics lessons and history lessons, federalism is a concept that began literally with the drafting of the Constitution and the concern about the Bill of Rights, where power was centered in and around a federal government as opposed to giving much power to state or local governments. And so that concept of federalism was often pushed by, actually promoted by several of the founding fathers, where they wanted the country to be more of a central government located in wherever it may have been at that time period, New York or Philly or wherever, with that power centered in a centralized federal government as opposed to giving much power to the states. And so that concept is one where that power is centered in and around a strong federal government as opposed to having power shifted through other portions of the government.
Okay. All right. Any of the panelists want to add to that?
That's exactly what it is. I think the only thing I would add to it is that the concept was for the federal government to grant certain powers to the individual states. And that's where the big debate nowadays comes in, federalism versus states' rights. And you're seeing that debate probably on a score of issues. For example, the last few years there have been several states that have legalized the possession and use of marijuana, which is a scheduled drug against the laws of the United States. So you see that as a good example of federalism versus individual states' rights.
Wonderful. Thank you so much. One also hears about talk of the three branches of government. What are those three branches?
Real basic civics lesson is the three branches are the executive, legislative, and judicial. And for those who are unaware, the three branches are supposed to interplay in a way where they keep each other in check, and none of the branches get too powerful. And the three branches extend all the way from the federal government all the way down to the local level. So while we have federal courts and federal courts of appeal, federal district courts, the Supreme Court, those are the federal judiciary. We get to the legislative branch on the federal level is obviously Congress, and then the executive is the president. But that same concept goes all the way down to the local level. At the state level, we have the governor, we have the Georgia Supreme Court, the Georgia Court of Appeals, the superior courts and state courts in the state level, and we have the legislature, which I pleasantly get to go visit in a few weeks. And then you get all the way down to the local level, and you have city councils and county commissions. You have a county commission chair, you have a mayor, you have municipal level judges, you have probate level judges, magistrate level judges, and the council and commission is the legislative branch. So it's something that just is deeply involved in the American political culture and civics background, I guess.
Okay. Now you've done a good job of outlining the three branches, but what is the function of each of those branches, the legislative, executive, and judicial?
Tom, you want to do it? You want me to touch on it?
Yeah, you and
The legislature makes the law. In simplicity, speaking in a simple form, the legislative branch is responsible for making law. For example, as Rushy said a moment ago, on a federal level, we'll see the houses of Congress, the Senate and the House of Representatives, make law. The executive branch on a federal level, the president, the vice president, his or her cabinet, are responsible primarily for carrying out those laws. And then the judicial branch is responsible for reviewing the laws. And by that I mean there may be a challenge to the law, and that challenge will be reviewed by the court. So as Rushy said a moment ago, each branch has a check and balance on each other, and the Founding Fathers did that for the purpose of not allowing one to become more powerful than the other. But simply speaking, that's what each one does.
Okay. And I know you did mention the checks and balances. That's a great lead into our next set of questions. So basically, under the checks and balances system, the Founding Fathers set it up to where no one branch was dominant over another branch or the other two branches. Correct?
That's correct.
And so this is not some abstract concept. This has very real world implications for us as citizens in everyday life. Correct?
It does. And this is where I think the majesty of the Constitution, both the federal Constitution and the state of Georgia Constitution, really shines. If government works the way the three branches are checks and balances on each other, it is a perfect way for the citizens to be represented and for those laws to be interpreted and carried out correctly. Of course, there's always that debate of whether an executive is overstepping their boundaries or whether the legislature is overstepping their authority in interpreting laws. And of course, I think over the last few decades, there's been a lot of spotlight on the judiciary as actually legislating as opposed to interpreting the laws. But I think it's important for citizens to note that really it is, in my estimation, the most purest form of government, having the checks and balances, having all three branches working in concert with each other with very defined areas of authority that best represents the citizens.
Okay, thank you. Just to kind of sort of put a concrete example to sort of what Mr. Chairman, you just got through saying, let's say that some person is thought to have committed a crime and that person is inside his or her home. Can the police simply pull up in their squad car, kick in the door, arrest the person, and not read them his or her rights?
They can on TV, but not in the real world, Joel. There's a lot of various constitutional protections of individuals, particularly in their home. That doesn't mean that if law enforcement is chasing an individual and there's what the law would consider exigent circumstances, they may very well enter into a person's home to apprehend that individual. But as a general rule of thumb, a man's home is his castle, and so it's protected by the Constitution. And for law enforcement to have the authority to go into that home to seize an individual or to seize property in that home, they have to go through another set of checks and balances. They'll go to a judge. They'll explain to a judge the reason for wanting to enter that home. That judge independently will then make a decision whether or not he or she will grant the authority under an arrest or a search warrant for the home. And so that's another filtering system for law enforcement to have to go through before they're allowed to enter into a person's home. So as a general rule, the individual is protected there. It doesn't mean he or she can commit crimes and get away with it. It just means that in order for law enforcement to appropriately, legally, and constitutionally make an appropriate arrest, there's a number of filtering or checks and balance systems they have to go through to make that happen.
So I guess to build upon what you just got through saying, so if under that scenario the police went to a certain judge, said we want this person to be charged and put in jail and so forth and so on, the check and balance where the judge could say you didn't follow protocol, so therefore the person either had to be released or the property has to be turned back over to the person, things of that nature.
Certainly. I mean, that happens on occasion. You know, we want our law enforcement to do the job the correct way, the legal way, and we're blessed in this county because the vast majority of the time they do just that. But on occasion, there may be a circumstance where law enforcement doesn't have enough evidence. There may be a circumstance where one judge says you have enough evidence and a judge at a higher court level says no, you didn't, and overturn it then. So yes, those are circumstances that do occasionally happen where an arrest is not proper or an arrest cannot be made or a search wasn't proper, or if it was done in an improper fashion, the merchandise, the items, the property has to be returned.
And you know, this is the beauty, Joel, of the Constitution again. And again, as you said, the Civics 101, I think just to remind the audience that when we talk about amendments to the Constitution, these are guarantees to the citizens. This takes us back to the framers of our Constitution. In order for them to all be in agreement that they would form a form of government, which they ultimately did, the Constitution of the United States had to be amended 10 times before it was ever ratified, passed and ratified. And those first 10 amendments are what we call the Bill of Rights. And the Bill of Rights, and you touched on one, which would be the Fourth Amendment, rights of persons to be safe and secure of their person and of their home, was one of the founding pillars of the Bill of Rights before the Constitution would even be ratified originally. And that's the beauty of a Constitution, to protect citizens.
And I think to add on that, it's important to know the hierarchy of laws in this country is the Constitution is the highest law of the land. And that means that state laws and other federal laws and local laws fall underneath it. So if there's a conflict, the Constitution or whatever higher law there is would take control. And it's important to know that the rule of law is what makes this country so great in what it is, because not all other countries are that lucky. Some other countries may be in a theocracy, or they may have a dictator that everything comes from the word of mouth. You look at North Korea. So the rule of law and the Constitution is what sets up our entire system of or legislative branch or executive branch or judicial branch, and how everything operates from the federal level all the way down.
Thank you. Again, to do another example of this checks and balances, let's take it to the state level. We were talking about the county earlier. After a flurry of social media and national media stories, say that both chambers of the Georgia General Assembly decide to pass a law that completely legalizes, for whatever use you want, marijuana, heroin, or cocaine, and the governor does not support it. How would the checks and balance system work in this case if the governor didn't want to sign that bill?
Well, that's again what a term that a lot of people hear, and that's a veto. And the executive branch has a veto power over any legislation that comes to his or her desk. Of course, that veto can be overridden by the legislature, and you see there goes the checks and balances kicking in again. The executive, who may feel that a state law that was passed by the legislature was ill-advised or is against public policy, would have the right to veto that legislation. Likewise, when that vetoed legislation goes back to the houses of the legislative body, then they can override that veto, but it's very hard to do because in most states, as well as certainly our federal government, it takes 2/3 of a majority of the two houses of Congress to override a veto. So a presidential veto or a gubernatorial veto is very powerful in most instances.
Okay, well, I appreciate that. Now, Mr. Patel, you don't work for a particular branch of government per se, correct?
Correct.
All right, because you mentioned you work for the Georgia Municipal Association, which is itself I guess a group that lobbies, amongst other duties, the members.
It's
of the
a membership
legislature.
organization with the municipalities. So we do a lot of things. We're a nonprofit corporation under the state laws of Georgia and federal law, and so we actually lobby for these cities, but we also do things like provide insurance and workers' comp and a lot of training. We do a lot of training for local elected officials, from topics as varied as open meetings, open records, to how to make your municipal courts operate correctly, to how to do a budget correctly. So our organization is pretty widespread as far as what we do with training. I think next year we're offering 50 different training classes. So
Now, do you yourself participate in those trainings?
I do. Mostly I deal with trainings and teach trainings related to the law. So I teach municipal law classes, open meetings, open records. I do the municipal courts training at least once a year, usually twice a year. And after the legislative session, if there's a new law that requires a lot of new information to be disseminated to our members, we'll have a special training on that new law or laws as it comes up. So that's kind of a, what does the legislature do that is going to confuse our folks, and then we have to create a training program for it.
Now, you mentioned that not all the cities in Georgia are members of the association. How does a city become a member, and how does one not become a member?
So most cities in Georgia are members. There are a few smaller cities that aren't, and in order to become a member of the municipal association, there are dues, and our dues are based upon the population of the city. So it's a percentage related to the population. So the city of Atlanta obviously has the largest membership dues because they're the largest population-wise city. Some of these smaller cities choose not to become members of the municipal association, and when I say smaller cities, they're pretty small. We actually have 80% of the cities in Georgia are actually 5,000 people or less. So when you're talking about Georgia cities, most of them are small to begin with. But the smaller ones choose not to become members of the municipal association for a variety of reasons, mostly because most of those cities exist to provide 3 services, and they might not have employees, and they do the bare minimum that is needed to be done to remain a city, and that's about it.
Okay. So your membership is not determined by the model the city follows, like whether it's a Sandy Springs model of government versus a traditional, maybe Marietta city of government.
Well, and that's a great question, because in other states there's actually different levels of cities. So in other states you may see boroughs and townships and towns and municipalities, and Georgia is not like that. Georgia actually only has one type of city, and it's a municipality. Now, those cities that we see all through the state are organized differently under the general umbrella of a municipality. So you may see something like a Sandy Springs that has a lot of contracts with private entities to perform the services that the city does. You may see other cities like Peachtree Corners that really do zoning and a few other key services, but they don't have a police department and things like that. Whereas on the other end of the spectrum, you'll have the city of Atlanta that has a high volume municipal court, a large police department, does water, sewer, does almost anything a city can do in the state. So while cities have the ability to do a variety of services, they all do fall under the same category.
And you mentioned earlier that lobbying work that your organization does at the legislature, I would assume that means lobbying to have bills enacted that are favorable to your members, as well as maybe kind of hopefully stop ones that you don't think are favorable to your members.
That's absolutely correct. So we deal with a lot of legislation every year, and we end up having to read pretty much every bill that's introduced because of that, because local governments in general have issues that are in almost every title of the Georgia Code, which is like every chapter of the Georgia Code. And so we do end up playing defense a lot. And the county association isn't very different on that regard, as both local government associations do play defense a lot on legislation, because legislation can have harmful effects on local governments, counties or cities. If there's a change in the tax law, it could mean tax money is being taken away from the local level and given to the state level, or just taken away in general. And you know, when there's a loss of tax revenue, that could lead to issues as to how is the road going to be paved, how are the potholes going to be fixed, how are the police officers going to be paid, how are the firefighters going to be paid. So issues like that can come up, but the issues that we deal with are so wide and varied that we often joke about some of the issues. I've dealt with bills ranging from things like golf carts to actual in-depth issues like probation, and how probation services are conducted in the state. So we do cover a lot of areas, and our legislative staff, we tend to separate into key focus areas, so each person gets a key focus area. We do interblend, but we cover a lot of topics.
And I think you mentioned this earlier, but there is a separate organization for the county governments, yes, as opposed to the city government.
Right. So the Georgia Municipal Association represents the 500-something cities. The county association is called the Association County Commissioners of Georgia. And we work closely with them on a lot of issues. We don't always agree, We tend to agree on many issues until it comes to revenue, because unfortunately, when it comes to revenue, there's only one piece of pie, and sometimes that leads to conflict. But we do get along with them pretty well. And there's 159 counties in the state, so the association county commissioners actually has all 159 counties in their association.
Now, I wanted to kind of touch base on the difference between the city and county, since you did reference some of those. Obviously, the city government has to have its own structure that's separate and apart from the county in which it sits, correct?
Correct.
And that structure consists of the mayor and the city council and the city courts.
Right.
Correct.
And not every city has a municipal court. There's only about 370 cities that have a municipal court. They're not required to have a municipal court. And some cities choose not to. They might not have a police department because cities aren't required to have police departments. Many cities do, but some do not. So the differences between cities and counties are varied, and they've changed over time in Georgia. A long time ago, counties really only dealt with roads. They were the boards, the commissioners of roads and revenue, really. So they were dealing with taxes and roads. But we've had many iterations of the Georgia Constitution, and as the Georgia Constitution has evolved, counties have actually become more city-like in the services that they can provide. So in a lot of ways, they've become very similar, but they've also remained different in a lot of key aspects, such as the types of courts that are related to them. So counties have constitutional officers, like the clerk of the Superior Court and like the sheriff. Cities do not have constitutional officers, and constitutional officers are officers actually set out in the Georgia Constitution, and they're required to be existent in these counties. Cities can pick and choose the services that they provide, and as long as they provide 3 core services, they can remain a city, whereas counties do have requirements laid upon them by the Constitution, such as having a sheriff, having a superior court, having a tax assessor doing the taxes, things like that.
But in the city model of government, the mayor is the executive and the city council is the legislative function.
Correct.
Of the structure, and they basically are checks and balances on each other as well, correct?
That's absolutely correct. Counties can be a little different. Most counties have a county commission and a county commission chair, but there are counties in the state that actually are sole commissioners, which is always a running joke of how does a sole commissioner have an open meeting, because you're talking to yourself. But yeah, counties can be a little different, but cities have a mayor and a council. Now, how powerful that mayor can be and how powerful that council can be depends on that city charter, which is the basic law of the city. The city charter is something enacted by the Georgia General Assembly, and it sets out where the city is, first of all, and most importantly, but it also sets out the key aspects of that city. How much power does its mayor have, such as can the mayor veto legislation passed by the city council, or is the mayor just sitting there and not able to veto things and just calls things for votes? There's a lot of varied city charters in the state, and we like to call, there's 3 basic plans of the city charter. There's the weak mayor, where the mayor doesn't have much power. There's a strong mayor, where the mayor has a lot of power, such as the veto power. There's also something called the council manager form of government, where a city council hires a city manager, and the city manager is the one that operates the city and runs the day-to-day operations and makes all the decisions.
Do you know, amongst the cities that exist here in Cobb County, what model they follow of the 3 you've outlined?
I don't know what kind of model they follow in Cobb County with Marietta and Smyrna and Kennesaw, but I do think that I think that the mayors in Cobb County tend to be very involved in our municipal association, so I would imagine that they have at least some pull in their cities.
They're not just merely calling votes.
They might not be.
Okay. Now, I know, like, for example, the federal government can sort of threaten to withhold federal highway funds if a state does not decide to increase or decrease the speed limit. Does the county have that ability over city government? Can they cause the city government to say, I want you to do this, and here's what I'm going to do if you don't? Is there such power in Georgia?
So cities cannot willy-nilly make their own laws if the state has already preempted that field. So when it comes to certain things like speed limits, it depends on the road and type of road. But there are different road systems in the state. There's a state road system. There's obviously a federal road system. There's county roads, and then there's city roads. So I think it will depend on what we're looking at in this specific instance.
But just for, I guess, that's sort of an example, I guess. Is there, in other words, in a larger sense, can the county make the cities do its bidding? Like if the county says, I want the cities to fall in line behind what we, the county, want. Like if Cobb County says, Marietta, Smyrna, Ackworth, Kennesaw, I want you to do this, and I will make you do this. Can they?
They can't force the city by just pure rule to do what they want, but they do have some ability to pull some strings and say, look, we need this done, we can work with you, and they negotiate on certain things. And so there's a strong interaction between cities and counties on getting what you want. So I think a great example of that would be every 10 years or so, we have something called loss negotiations. It's the local option sales tax. And the local option sales tax comes about because of the new census, which is done every decade. And the local option sales tax splits that revenue pie between cities and counties. And there's always a negotiation going on between the cities. And not every county has one city. Some counties like Cobb have multiple cities in them. And so the cities negotiate with the county on how to split that pie. But in that negotiation comes something called service delivery strategy, which is a discussion and an agreement on how different services are going to be provided throughout the county, including in the incorporated areas, and how that's going to be paid for. And so through all those negotiations, what ends up happening is people are able to somewhat impose their beliefs and will to get what they want. Now, do they always get everything they want? No. That's another example of actually checks and balances is cities and counties having to say, okay, well, we didn't get everything we want, but this is going to be workable for us, and we can pay our budget and pay our police officers, and you guys can do the same thing.
Okay. All right, great. Thank you. Simply because a city is located within a county doesn't mean that none of the actors of the county can act within the city, correct?
Right.
Okay. So to use an example, let's say a huge fire breaks out in the city of Marietta, and let's actually hope that would never happen.
Right.
But let's say it does. Who responds to that fire first?
So most cities and counties, when it comes to things like that, will enter into things called mutual aid agreements. And these are actually great concepts that the Georgia state law allows. So if there was, God forbid, a great huge fire here in the downtown square, the first people to probably respond would be the Marietta Fire Department because they're the closest. But if it's a big enough fire and they need help, if they have a mutual aid agreement, which they most likely do, with the Cobb County Fire Department, they'll get the Cobb County Fire Department in to help them with that. And it'll help put the fire out quicker. It'll save lives, obviously. It'll save property value. Now, will things obviously go down in flames? I mean, if there's a fire, most likely. But the more firefighters you have at something like that, the quicker it's going to be put out and the quicker it's going to be saved, which is why these mutual aid agreements are a really great concept.
Okay. And let's turn to an illustration that would be involving something criminal. Let's say a driver commits a crime in an unincorporated Cobb County, and then he enters the city limits of Smyrna. So once he's inside the city limits, can this accused driver stop his car long enough to make a face at the Cobb County officer and then drive off into the sunset with impunity?
And
anybody on the panel can answer that question.
Well, if he does, he'll probably be facing another charge as well as the first one. But no, Joel. In fact, touching a little bit on what Rush, you said a moment ago, Cobb is an interesting county because it's a large county, and we have a large unincorporated part of the county, but we have 6 municipalities that operate within the boundaries of Cobb. And so from a law enforcement perspective, it's interesting as the DA we not only deal with cases made by the large Cobb County Police Department, but also made by each of the 6 municipalities within Cobb. They each have a police department. They make cases. Those cases come to us just like from Cobb. And in your example, if, for example, someone's committing a crime, a traffic violation in unincorporated Cobb, and there's a Cobb officer after them, that doesn't mean that once they enter into the city limits of Marietta, that Cobb officer has to immediately stop his or her vehicle and allow that person to proceed on, or call Marietta, for example, and say, you guys need to pick up and help us. They probably would in that circumstance, but the Cobb officer would be authorized to continue on. As a general rule of thumb, the municipal officers are restricted to the areas, geographical areas that their cities are defined by. That's where they police. The sheriff's department's a little different. The sheriff, being a constitutional officer, has the authority countywide. Even the Cobb PD officers, they're limited geographically to the unincorporated part of Cobb. But if they're in the middle of an investigation, they're in the middle of a chase, they're pursuing someone, just because they cross municipal lines geographically doesn't mean that chase or that pursuit has to end.
Okay. So if, for example, someone is in a city court and they want to ask for a jury trial, that means they would be bound over to the state or superior court at that point?
That's correct. That's an interesting concept, and it's a good question. Not many people realize that. But if you're in a municipal court, hypothetically, let's say that you have someone's charged with a DUI in the city of Smyrna, and they go to the city of Smyrna and they say, I'm not guilty. I want a trial. Now, they have a couple of options. One is to say, I want to keep it in the city of Smyrna, and I want a trial, but that can only be by a judge, because the municipal court doesn't have the authority to have a jury trial. So if that individual said, I want my case tried in front of a jury, he or she would bound that case over to the state court of Cobb County, which would then obtain jurisdiction of the case, and that individual would have the opportunity then to have 6 individuals, jurors, decide his or her guilt or innocence. So you can keep it in the municipal court, you can dispose of it there, but if your ultimate goal is to have a jury trial, you'll have to send that case up to the Cobb State Court for that to happen.
And I think something to add on that is sometimes what you may see is in a municipal court level is somebody may ask to have a jury trial, not because they actually want a jury trial, but because they want the time to get themselves together and get themselves organized. And going to a state court to have a jury trial will take some time, and it might give them the opportunity to get themselves situated, and that's unfortunate on the prosecutor level, but it does happen.
Now, I will tell you this too. I don't know about other jurisdictions, but in Cobb, when you tell a municipality, for example, using the example we used a moment ago, if you're in Smyrna and you say, I don't want to dispose of my case in Smyrna, I want a jury trial, and that jury trial, that case is sent to Cobb State Court for the purpose of jury trial, you better be ready. Mm-hmm. Because when they get it, they're not going to dilly-dally with it. They're going to put it on a faster track, and they're going to hold your feet to the fire to make sure you get exactly what you ask for.
Okay. So be careful what you wish for, huh?
Absolutely. Right. Mm-hmm.
Now, does a case that gets bound over to the state or superior court get handled any differently once it arrives there than one that started out or originated in the unincorporated Cobb County?
It has that potential. It does, because you're another set of eyes in that another prosecutor is looking at it. The municipal prosecutor, using our example from a moment ago from Smyrna, would not go up to Cobb State Court and prosecute that case. There would be new prosecutors who would be handling it. There would be a new judge who would be hearing it. And so you have another set of eyes looking at the case, and there is some strategy behind that. For example, you may be in a municipality that tends to fine a case at a very high rate. They just may say, this is our standard fine for this particular offense. A good lawyer may realize that if I send it to state court, I know that the fine for the same offense may be less, and so that may be some of the reasoning behind that. But again, the municipalities and the state court don't want you transferring cases simply for the purpose of saying I can pay a lesser fine in state court than I could in the city of Smyrna. You transfer that case for that singular purpose of saying I want a jury trial. And so when the new prosecutor and the new judge sees that case and realizes, and they will realize, depending on what the file is, that you've sent it up there for that singular purpose of a jury trial, and you get up to the court and you say, I've changed my mind, which is your right, but it's also their right to fine you as much as the statute or the law will permit. It's also their authority to recommend punishment that may be greater than the municipality. So you take all of those factors into consideration when you ask for that transfer.
Obviously, you mentioned being the district attorney for Cobb County. I know some circuits have multiple counties in them. It could be 2, 3, 4, 5 counties in one circuit. Is Cobb its own circuit?
It is. Joel, it's one of the 15 single county circuits in the state of Georgia. Georgia's interesting, and as Rushy touched on a moment ago, 159 counties in Georgia have a sheriff. 159 counties in Georgia have a superior court clerk. And so those particular counties, they may be a small county, but there'll be a sheriff there. That's not true with a district attorney. There are 49 judicial circuits in the state of Georgia. One of my colleagues has 8 counties in his circuit, which means he deals with 8 grand juries, 8 sheriffs, 8 county commissions, and so that's a wide variety of individuals that he or she may deal with. Cobb, because of the size of our county, is a single county circuit. So it's not mandatory under the law, but because of the size of our county, we are a single circuit. I do not have to be concerned with any other counties other than Cobb, and so I'm blessed in that regard. Even though we're a large county and a busy county, I don't have to concern myself with any activities in any other places with the exception of Cobb.
And how long has Cobb been its own circuit? You know, has it like been 20 years, 50 years?
It's been more than that.
Oh,
Gosh,
yeah.
Tom, it's been...
We used to be part of the Blue Ridge Circuit, which ran all the way from the southernmost boundary line of Cobb County, where it touches the city of Atlanta in Fulton County, all the way to Chattanooga on the northwest side. And I believe it was 1954 that they started breaking up the Blue Ridge Circuit, and I think Cobb became a single county government shortly thereafter. And it was, we've only had, by the way, something like 5 elected district attorneys over that period of time for a single county circuit that Cobb County has been. So it's been quite a while, over 50 years or so, that we've been a single county circuit, where we evolved from the Blue Ridge Circuit. But as Vic says, a county the size of Cobb, it would be unruly and almost impossible for a constitutional officer like a district attorney to have more than a jurisdiction bigger than Cobb County.
Okay, all right. Now, I guess turning to the county and county government structure, obviously we have our own checks and balances here in the county as well. I guess you obviously have a chairman of the county commission, that acts there. And in that scenario, I guess would your chairman be deemed to be the executive officer and the board of commissioners be the legislative, or are they all considered to be executive together? How is that termed or deemed?
I think it's kind of a interesting combination. I think the county commission is the legislative body. I think that's pretty clear. The county chairman does have some executive powers, but may also be part of the legislative branch, and that's actually not that different from a lot of cities with the mayor and council, where the mayor can also be a part of the legislative branch, but also has executive powers. So.
And then Cobb County has its own judges too. That the judges don't have to ride a circuit here in Cobb.
That's correct.
Okay. Can judges in Cobb County strike down a county ordinance as being unconstitutional?
They can. There are instances, and it happens more frequently than people would believe, that there could be action taken either by the county commission itself or through an ordinance, county ordinance they may have passed that is either illegal or it's unconstitutional. And in that case, an effective party can file action in the court of general jurisdiction, the only court of general jurisdiction in the state of Georgia, and that's the Superior Court of Cobb County. That is a constitutional court that was created by the Georgia Constitution. Like the district attorney, the Superior Court judges are state constitutional officers. We presently have 10 Superior Court judges who sit on a daily basis and hear everything from felony criminal cases to domestic relations cases and to cases and civil cases, as well as, and this is very important where this may come into play, not only interpretation of ordinances, but a court of equity to decide equitable relief for a party. It's a unique court in that regard. But they, yes, to answer your question, under certain circumstances, they have the right to interpret and to possibly overrule action of the county commission.
Would the party approaching the court in that scenario have to been wronged by the ordinance in question, or could they be anyone in the county?
They generally have to have standing, and what that basically means is they have to have some interest in the outcome or the action, either adversely or in some regard that they are a party litigant. In other words, they are harmed in some way by the action taken.
Okay. Now, can the judges rule against the county on its decision on a particular zoning case and determine what the county did was illegal?
They can, under those circumstances too, in certain, and again, there has to be a number of questions answered before they can, number one, assume jurisdiction, and secondly, get involved. But yes, theoretically, they could.
Now, is the district attorney, is he considered, or she considered to be an employee of the county or a state actor?
Actually, the district attorney is a state employee. It's an interesting relationship with the county, Joel, in that a number of my employees are county employees. Some of my prosecutors are state employees. The majority of the budget that operates the Cobb District Attorney's Office is supplied by the county government, by Cobb County. Some of my employees, being state employees, are paid by the state, and so it's a hybrid relationship. But the elected district attorney, as Tom mentioned a moment ago, is a constitutional officer and is a state employee.
Okay. Now, can the district attorney act as a check on the Board of Commissioners? And if so, in what way?
Well, the district attorney's power is in my function as DA is limited to the prosecution of criminal acts by individuals within the boundaries of my circuit, which would be Cobb County. It doesn't make any difference if it's in a municipality or in unincorporated Cobb. I still have the authority to prosecute those individuals for felony crimes. So my jurisdiction over any citizen, be it a Cobb County commissioner or an individual who does any other employment within the boundaries of Cobb, or who is just a person who is in Cobb, if that person commits a felony crime, then I have the authority to prosecute them. I don't have any authority over a county commissioner if he or she does an act that somebody may challenge from a constitutional basis, that somebody may challenge on a zoning issue. That's not my bailiwick. But if, and with all due respect, I have a lot of good friends on the county commission. I know none of them would commit a felony act, but if one of them did, then yes, I would prosecute that individual just as I would anyone else.
Well, so that's a great distinction you made. So you don't get involved in constitutional questions, but in the issues of malfeasance or accused malfeasance, that would be something that would give rise to you having a case to open in the district attorney's office.
It would. For example, let's say hypothetically that someone comes to us or law enforcement comes to the DA's office, which is the way the majority of cases come to us, through law enforcement channels, and they indicate to us that there's some type of criminal act by a sitting elected official anywhere in the Cobb. It doesn't have to be a county commission. Could be somebody on a city commission. Could be a municipal judge. Could be anyone of that nature. Then we would have the authority then to conduct an investigation. In fact, I have a unit within the office that does not only white collar but does public integrity issues, and so they would have the authority then to investigate, and if we believe that probable cause existed that that individual committed a felony crime, then we would have the power and discretion to prosecute that person.
And by that same token, would the DA have the ability to then also prosecute crimes against sitting judges? if they committed some act of malfeasance in their position as a judge?
If it's a criminal act and it fits within the statute that we can show, and we're comfortable that his or her actions as a sitting judge violated a felony act of the state of Georgia, then absolutely we could prosecute a sitting judge.
Okay. I mean, I realize that would be very rare indeed, but just technically that could happen.
Yes.
Oh, okay. Now, I guess let's take a scenario where, again, getting back to kind of the criminal law element here in the county, and let's say you have a standoff situation. You say a husband decides to, in his own home, decides to take his wife and children hostage. Obviously, a very terrible scenario. Again, they're in their marital home. The home is clearly located inside of a city. Who does the wife call if she's trying to obtain escape from her husband? City police or the sheriff?
In that scenario, we're fortunate here in that when you call 911, 911 will dispatch the particular appropriate law enforcement agency to that individual's home. As a general rule of thumb, the responding officers initially will be geographically where that home is located or wherever they believe a crime or a call originates from. Example, let's say that this person you mentioned is in the city of Austell, within the city boundaries of Austell, and they reach out with a 911 call indicating something is going on in that home. Then the initial responding officers would be from the city of Austell. That doesn't mean, Joel, that city could not reach out for assistance to the Cobb SO on occasion, to the Cobb PD, to larger departments that may have more manpower, that may have more equipment, that may have the wherewithal to deal with those particular instances in a little bit easier fashion than a smaller municipality would. But the initial responding agency, the responsibility would lie geographically wherever that call originates from.
And would a file be opened up in the city of Austell under your scenario, or would it be actually opened up in the district attorney's office? Because that probably was a felony item.
Initially, the job of the law enforcement, responding law enforcement officers, and ultimately any detectives or investigators they bring in, their responsibility is to investigate that particular call, to investigate that particular matter, and determine whether or not felony charges were appropriate. That doesn't mean that on occasion they don't reach out to us. In fact, in this county, we're pretty fortunate in that what we do. I have units, for example, major crime. Let's say, God forbid, that there's a homicide in the city of Powder Springs. My major crime unit will be contacted because we have that type of partnership with law enforcement. They will reach out to the DA's office. My major crime unit will respond. One of my major crime prosecutors, one of the investigators, they'll be there to assist, not to get involved in the investigation, but to assist. For example, law enforcement may say, we need help getting cell phone records, so my folks will step in and assist in that regard. But the function of law enforcement is to investigate and determine whether or not charges should be filed. Once they make that determination, they then go to a neutral and detached magistrate judge and say, Your Honor, we believe charges ought to be filed against this person. Here's why. Once that judge makes a decision to issue a criminal warrant and it's a felony crime, then that file will eventually make its way to the district attorney's office. We will bill from that file, from that law enforcement file, the warrant, the police reports, the interviews. We will build from that into what we call a prosecutable file, one where we're ready to step in a court of law and prosecute the case after a grand jury indictment. So the initial investigation, the initial file will be completed by responding law enforcement. It will eventually work its way on, if it's a felony case, to my office. We will bill from that file to eventually make it a file that's prosecutable in a court of law.
And using the example we gave earlier, let's say that in the situation that the wife and children released unharmed physically, the husband either gives himself up or the police come in and get him. Either way, what happens to him? Is he arrested and sitting in a city jail, or is he taken to a county jail?
And he will eventually end up in a county jail. A lot of municipalities, even the ones in Cobb, have slowly over the course of time gone out of the jail business. And the reason why is we're fortunate here in that there's no good jail, but the jail we have in Cobb is unincorporated Cobb, run by the sheriff's department, is run in a professional manner. It's a clean facility. It's operated appropriately. So a lot of the smaller municipalities will transport those inmates to the Cobb jail, run by our sheriff, and they will be housed there. A couple of the municipalities still have jails where they will keep municipal prisoners. For example, somebody may violate a city ordinance or violate a law that the city can prosecute, and they may be sentenced to 20 days, 30 days, 10 days in jail, and they may stay in the municipality. But an individual in your scenario that's going to be facing felony charges will end up being incarcerated in the Cobb County Jail that's run by our sheriff.
All right, and then in that scenario, what then happens for the victims of that crime? Is there a unit in the city government that basically helps console the victims, gives them support, and so forth? Or do they automatically go to the victims unit that exists to support victims in the Cobb DA's office?
Initially, there will be some contact with a victim by the responding law enforcement officers. That doesn't mean that they will maintain a relationship with those individuals. And I don't mean that in a flippant or disrespectful way, but law enforcement's job is to respond to calls, to investigate crimes, to make some determination of whether or not charges ought to be filed. What happens in our county is that we have an active victim witness unit within the district attorney's office. So if someone is a victim of a felony crime, my victim witness unit will reach out to that person, will make services available to that individual, will make that person aware of any future court dates, will make that person aware of any issues where the individual may be released on bond so he or she can come to court and speak on that matter. In fact, Joel, it's interesting you asked that question. We're in the process now of trying to set up a new program where we have a victim witness person at the jail. When an individual is arrested, they have what we call a first appearance hearing. By law, it's within 72 hours, but Cobb is a little bit more progressive, and they have him twice a day. So if an individual is arrested, he or she's going to be in front of a judge at 8 a.m. in the morning or 8 p.m. at night on virtually the day of or the day after they're arrested. So we're in the process now of trying to put a victim witness individual in that first appearance hearing so we can make sure the victims know every single aspect, every single step of the case, even from virtually 24 hours after the arrest forward. The majority of time, our victim witness individuals get involved with people at the first court appearance, which is the probable cause hearing, and that may be 2 to 3 weeks after the arrest. But we're doing our best to start a new program here where we have a victim witness person at the jail almost immediately so we can let victims know this is what's happening in your case. And I will say this, too, about the Cobb Sheriff's Department. They do a fantastic job of reaching out to victims and telling them the perpetrator of the crime against you is getting ready to post a bond. He or she's going to be released, so you need to understand that. Judges do a good job here of making sure that if they give a bond, they say, don't have no contact with this victim. You can't get in touch with this victim. You know, common sense would dictate that sometimes a piece of paper doesn't stop an individual from doing that, but I think the system, particularly in Cobb, is geared to do everything it can to protect victims.
And to be clear, in the Victims Assistance Unit in the District Attorney's Office, there's not actual psychiatrists, psychologists, counselors who work directly as employees of the department. You refer those services out for the victims.
That is correct. We have a victim witness unit. Literally, Joel, we have victim witness advocates assigned to every single courtroom in the Cobb Superior Court, the Cobb Magistrate Court, and the Cobb Juvenile Court. We don't reach out to the state court because we have a very fine solicitor's office in this county that does that. But yes, what we do is we sit down with a victim and we may say, this is a professional person that we would recommend that your child see if the child is a victim of a crime, or that we would recommend that the family see in the event it was as traumatic as a homicide, and we have those services that we would recommend. Those services are not located in the DA's office. They're generally professional or nonprofit individuals outside of the DA's office that we refer our victims to.
Okay. All right. Now, is there a scenario where an accused could be brought to justice for a violation of a state law and go before a state official, or would they always be tried in the county in which the act was committed?
Criminal law requires that an individual who is accused of a crime be tried in the county where the crime was committed. So if you commit a crime in Cobb County, you're going to be tried in Cobb. The only exception would be a case, and Tom can touch on this because he's tried a number of these very high-profile cases that just simply because of the media interest, a defendant, and this is not geared toward a victim, it's geared toward the criminal defendant. The defendant may not be afforded a fair trial in that particular county because of the media attention, and it may reach the entire jury pool to where you can't get a fair jury. In that scenario, the case would pick up and move to another circuit, another county away from Cobb. But generally speaking, one of the premises of criminal law is that you're tried in the county where the crime was allegedly committed.
Anything you want to add to that, Mr. Chair?
Well, as Vic mentioned, there are extreme circumstances when a case may get a lot of notoriety in which the local jurors have been so infected by public outcry or media attention on a case that it would require that case to be moved, because the jurors themselves would say, I cannot be impartial on this case because of what I've read or what I've heard or the impact that the crime has had on my community. And a good example of that is a case we had here just recently where we hosted the district attorney's office from Brunswick, from Glenn County, Georgia, where even we heard about it up here, but we weren't, we being the citizens of Cobb County, were not as affected as the citizens of Glenn County, where the little baby was shot in a robbery in the streets of downtown Brunswick. The district attorney, along with the judge who was assigned that case, contacted me as court administrator and said, would you be able to host our trial if we were to come to Cobb County to try it using Cobb County jurors? And of course we graciously agreed, and the judge, who was from Glenn County, and the district attorney from that circuit, and the law enforcement officers and all the personnel, defense attorneys, came to Cobb County. They selected a jury of citizens of Cobb County and actually physically tried it here. That's an instance where public attention, media attention was so great that they did not want to risk having that case, even if they tried it in that jurisdiction, overturned on appeal.
And I'll add on that particular case, that was a smart move to not take that risk, because having lived there for a number of years, and I wasn't there when the crime actually happened, but everybody I know down there knew every little detail, and that was not something where they would have found a fair and impartial jury in Glenn County.
Great. Thank you so much. Thank you. Now, can a person be arrested solely and strictly for violating a city or county code? What are some examples of that?
So with city and county codes, it's a little different. They could be arrested. Speaking on a city code level, it's very unlikely for a city ordinance violation that you'd be arrested. Most city ordinances, and I would imagine county ordinances, deal with things like too tall of grass or junk cars in the yard and things like that. So it's very unlikely that you would be arrested for that. You can end up facing a jail sentence for a city ordinance violation. Again, it's very unlikely that you would go to jail for a city ordinance violation, but I can't say it hasn't happened and it won't happen in the future, because sometimes people just blatantly disregard city ordinances and will violate them time and time again, and eventually the municipal court judge might get tired of seeing the same person in front of them for the same violation time after time, and think that the only solution is to put them in jail. When it comes to municipal courts, though, they're very limited as to not just the cases that they can hear, but the penalties they can impose. And city ordinance violations, at most, you're going to go to jail for 6 months, and that's very, very rare.
Okay. All right. Thank you. Now, do city or county officials have any influence on public policy on the state level? And if so, how?
I think I'll take that one. And the answer is definitely yes. City and county elected officials have a lot of pull at the state level because many of them have really good relationships with their legislative delegation. So that's their state elected representatives and their state senators. And that good relationship is actually key for the functionality of a local jurisdiction. Those state representatives and senators are elected in a certain area to represent the people of that same area, same as a county commissioner or city council member. So those relationships are utilized to relay what's going on at the local level to our state elected officials. And when new laws are passed or repealed at the state level, you can bet that if a state elected official, representative, or senator feels like that's going to impact their local community, one of the first people they're going to talk to are going to be their local elected officials.
So like if Mr. Reynolds decided he wanted to make sure some bill got passed by the legislature come January, how would he, is there a channel he would normally go through to accomplish that outcome?
There is. So with the prosecutors, they actually have a council called the Prosecuting Attorneys Council, and they actually have a good presence up at the Capitol, and they're well respected, especially in the judiciary committees, which is definitely the committee they want to be well respected in as prosecuting attorneys. And so if there's an issue that comes up with a prosecuting attorney, they'll discuss that with the Prosecuting Attorneys Council and try to come up with a solution. Most people and most groups try to come up with a solution that doesn't require legislation before they try to get legislation. But if there's anything anybody else would like to add, I'll let them take a shot.
Joel Rush is right. We have the DA's Association has folks who basically watch the law for us, the Prosecuting Attorneys Council, and occasionally lobby for us. But on certain instances, elected DAs will be called down to the legislature and testify in front of the commission. I give you a great example. One of the areas of concern that we have in Cobb, certainly through the DA's office, in fact, we've had panels on it through the Neighborhood Safety Commission, is the prosecution of elder abuse crime in Cobb and statewide, and we really, it's one of my passions as well. And back a couple of sessions ago, we had some concern about unlicensed personal care homes where the elders were not being taken care of, and we discovered that as we tried to prosecute those crimes, the majority of the law in that area, the punishment was of a misdemeanor nature, and we strongly disagreed with that. And working through local legislators in Cobb, I had the occasion to go down to the legislature, testify in favor of increasing the punishment of unlicensed personal care homes where our seniors were being abused, and that law passed, and it's now the law. And so to answer your question and to touch on what Rushy said a moment ago, I think local officials do have the opportunity to affect legislation even on a statewide basis, and you can go down there and testify at the Capitol, and on occasion the legislatures will actually listen to you.
That's always a nice thing, huh?
Conversely, and representing in my new position the Superior Court judges, the judges are very hesitant, even though they are elected statewide, state officers on a countywide basis, to go down and legislate, because remember again the three branches of government. The judiciary interprets the laws that are passed, so it is very unusual for judges to go down to the legislature to either lobby for or against any particular law because of their roles. That does not mean that they do not have an association that looks out for the interest of the judges. It's called the administrative offices of the courts that do but monitor legislation that may affect the judiciary. And there are instances where our Supreme Court Chief Justice or members of the appellate courts as well as superior courts may go down to the legislature to testify about certain laws. But you'll see a difference there, that the judiciary is very reluctant to take that traditional role of being influential to the legislature.
It's just sort of considered unseemly, I guess,
unless asked upon, and that's not to say it isn't done, but I think there is a hesitancy of the judiciary as a general rule to take on that role.
Okay. Now, of course, we've been talking in our scenarios about victims to some extent, but sort of ending on a positive note. Let's say there's a group of victims out there in Cobb County, since we're here in Cobb, and they're victims of drivers who drive while applying their makeup or who drive while shaving, and they've been injured by drivers engaged in these activities, but there's no law in the books that specifically prohibits these activities while driving, and they want to make a difference and make these practices to be against the law. So in this scenario, victims have decided to stop being victims and start being advocates. If these victims want to make the greatest impact, to what branch of government in the state of Georgia do they turn?
I think in that situation, the best branch to turn to would be their state elected representatives, their state representatives and senators, because that would need to be a state law change. And I think that's why it's important to know who your state representatives and senators are. Not everybody does. And I think it's good to get to know them. And if there's an issue that comes up, that's where you need to go.
So that would be more impactful than if they were to they wouldn't want to petition the county commission to pass an ordinance or their city to pass some resolution. That's not what they want to do. They want to go to the state legislature to do that.
Correct.
And Joel, on occasion, what may happen is these victims groups may reach out to, for example, the solicitor's office and say, we want this to be a misdemeanor crime. Would our Solicitor General, who's responsible for prosecuting misdemeanors, become involved and advocate that on our behalf as well? And again, that doesn't mean that he or she's any more important than the citizens who want it, but it may be somebody that the legislators would be comfortable with. For example, it's not unusual for a legislator, particularly local ones, to call me and say, as the Cobb DA, do you agree with this particular piece of legislation? How would it affect your office? What's the problems with it? And so I think Rushie's right. You go to the legislative body, but it's not unusual to get other elected officials involved. Sometimes that will help get a piece of legislation passed as well.
Likewise, I was district attorney during the period of time when there was a lot of debate concerning drivers under the influence of alcohol primarily, but drugs as well. And a group that now everybody takes for granted started up. They were victims' families of drunk drivers, and they started MAD, Mothers Against Drunk Drivers. And they became, as a citizens' body, almost without any support originally of any local public official throughout the state, became very effective in changing the DUI punishment and laws throughout the state and nationally, nationwide. So citizens groups sometimes can be very effective if they've got a good issue and they're tenacious enough to get to their state legislators to change the laws. And legislators are very open to that, as certainly our delegation is here in Cobb. If there is truly an issue that is of compelling interest to all of the citizens of the state, groups like MAD can be very effective.
Something to add on that is the key things with those presenting to their state representatives are representatives and senators love cold hard facts and they love specific stories. That way it makes it easier for them to relate it to their other members of their delegation when they're introducing a bill.
And so with the citizens group, could they come to your offices and say, would you please join force with us and go down to the legislature and advocate for these changes?
Absolutely. It's happened with pretty frequency in Cobb County with our office. So yes, they absolutely can.
Okay. All right. So it's fair to say that there is power in citizens coming together to advocate for an issue of importance, and they can make a difference.
Absolutely.
Certainly.
You're not destined to be a victim. You can actually rise up and be an advocate and make a good outcome out of this.
Yes. Yes.
Very much so.
Okay. Well, wonderful. Well, I think at this point, we're just about out of time. I certainly hate to call this discussion to an end because it's been fascinating, and I think we could go on much longer than this. And we're so blessed that each one of you has taken time out of your schedules. I know you're all so busy and do such good work on behalf of us here at the city, county, and state level. But we're very fortunate that you came and shared your expertise with us, and I hope that the members of our larger audience here were able to take this information, they'll be applied in their lives and feel empowered, because that's what we're hoping to accomplish with these kinds of forums, is people are educated and empowered by them. So we thank each and every one of you for your time tonight. Thank you so very much.
Thank you, Joe.
Thank you, Joel.
Trish.
Thank you for attending and watching on Cobb TV this evening. We especially want to thank our dynamic panel members and moderator. We are honored to have each of you as our moderator and panel members this evening. Our community is very fortunate to have each of you educating the community concerning judicial, executive, city, and county government. We commend you for your daily dedication to ensure our local county and state government is protecting all citizens. You are appreciated, and we thank you for your daily service. I know you don't get thanked enough, but we truly appreciate you every day. And the citizens of Cobb appreciate each one of you. A special thank you to David and to Brad for broadcasting this discussion on Cobb TV. Thank you for joining us this evening. We invite you to watch all of our 2013, 2014, and 2015 panel discussions on Cobb TV or link from the Neighborhood Safety Commission website. Please join us Wednesday, January 20th at 7 p.m. when our topic will be code enforcement. Thank you. Good night.